Hello, I'm Beth. I work as a Family Dispute Resolution Practitioner, or FDRP, at Catholic Care in Geelong. This talk will focus on some aspects of the law relating to family dispute resolution and FDRPs. There is no single source of the law relating to FDR work. Sections 10F to 10K of the Family Law Act, as well as the 2008 Family Law FDRP regulations are important, but plenty of law is contained elsewhere in legislation and in court decisions. Section 10F of the Family Law Act defines FDR. Broadly, it is about assisting people to resolve disputes post-separation and get on with their lives without needing to have long, expensive and often destructive fights in court. Importantly, it's also about motivating and assisting parents and other caregivers to focus on the well-being and best interests of children, rather than on winning the fight. There are a number of provisions that set out the musts, the must-nots and the mays for FDRPs. We will look at some of the key areas. First is the provision of information to participants in the FDR process. Regulation 28 contains a long list of types of information which FDRPs must provide to parties before commencing FDR. This includes information about matters such as confidentiality and disclosure obligations of the FDRP, as well as the general inadmissibility in court about evidence of what is said during the FDR process. Other provisions require FDRPs to provide information about the best interests of children, about parenting plans, and about services available to assist reconciliation. We'll look at the issue of admissibility. The Family Law Act says that evidence about the content of family counselling is not admissible in any court, state or federal. This covers both your file and your verbal evidence. The exception to this rule is evidence about child abuse. That is admissible. We'll come back to that shortly. The 2014 Queensland Supreme Court decision of Baden Clay has an interesting take on the term any court. It said that this term must be interpreted in the context of the Family Law Act definition of court, which means a court doing family law work. In that case, a family counsellor was required to give evidence in a high-profile murder trial. This decision has seemingly had minimal attention in other courts since then and may or may not be applied in Victoria in the future. Another noteworthy court decision is the 2010 Rassel and Ball matter, where the court decided that the FDR process does not commence until the FDR has been assessed as being suitable, and that work relating to the assessment of suitability is therefore not covered by the admissibility rule. Interestingly, the Attorney General's Department fact sheet for FDRPs about their obligations to clients says about this decision, the judgment is an unreported decision of a single federal magistrate and therefore not binding on other judicial officers. If the assessment process is conducted by a family counsellor with the inadmissibility provisions relating to their work, will Rassel and Ball apply? It seems to be a grey area. We will now look at the child abuse exception. There's a lot of law and a lot of learning about what constitutes child abuse, both in the Act and elsewhere. FDRPs need to be across this because it directly impacts on some of their obligations. The definition of child abuse in the Act has 4 parts to it. First, an assault. Second, involving a child in sexual activity where there is an unequal power relationship. Third, causing a child to suffer serious psychological harm, including as a result of family violence, and we note here that the definition of family violence is wide. And fourth, serious neglect. If it is a child abuse situation, there are 2 significant implications. First, evidence of an FDRP is admissible in court. Secondly, if it is a child abuse situation, FDRPs are mandated reporters pursuant to Section 67ZA. They are not mandated pursuant to the Children, Youth and Families Act, but they are mandated by the Family Law Act. DHHS unfortunately sometimes overlooks this important fact and leaves FDRPs off some of the lists they provide of mandated reporters. Do not be confused by such omissions. If you are an FDRP, you are a mandated reporter of child abuse. Now we will look at the confidentiality rule and some exceptions to that rule. What is said during FDR is confidential, subject to some important exceptions. I'll mention 3 here. First, an FDRP may disclose otherwise confidential information in order to protect the child from the risk of harm. Second, an FDRP may disclose otherwise confidential information for the purpose of reporting or preventing acts or threats of violence or property damage. Third, and importantly, an FDRP may provide information to an independent children's lawyer if they believe that doing so would assist the independent children's lawyer in their job of representing a child's interests. Be aware that in such may disclose situations, the Act says that unless it is a child abuse situation, the evidence of an FDRP is still not admissible in court. This can sometimes cause frustration for both an FDRP and others, such as independent children's lawyers, but the words in the Act are clear on this point and are actually stated twice in order that there be no misunderstanding. We'll now look at Section 60I certificates. Subject to a limited number of exceptions, people cannot commence court proceedings about children unless they have a Section 60I certificate from an FDRP. In other words, the law generally requires people to attempt to resolve matters in FDR prior to heading off to court. Exceptions to the general rule include urgency, child abuse, and family violence. A Section 60I certificate is in a standard form, giving the FDRP the option of choosing one of 5 boxes to tick. There is no room for comment or elaboration by the FDRP. The options available to the FDRP are: A, one party failed to attend; B, the matter is not appropriate for FDR; C, the parties attended FDR and made a genuine effort; D, the parties attended but at least one of them did not make a genuine effort; and E, FDR commenced but it then became inappropriate for the process to continue. The FDRP will decide which certificate to give on the basis of the totality of their interactions with each party. This generally means that some of the information they have from one party is confidential, meaning that the FDRP will often not be in a position to give detailed reasons for the decision they make as to which of the 5 options they have decided is the most appropriate one for them to choose. This talk has just skimmed the surface of the law relating to FDRPs. FDRPs need to ensure that they are properly aware of the musts, the must-nots, and the mays of the work that they do.
Make sure to check out our other family law related videos on our website, www.vicflpn.org.au.